Hello everyone, my name is Faruq Abbas and today I want to answer a straightforward question in employment law. Can an employee be punished twice for the same misconduct? The answer to this question is no. And in explaining the answer to this question, I would narrate the story of a live Nigerian case that went all the way from the High Court to the Court of Appeal and to the Supreme Court. It's a recent decision. And what happened in this case? An employee who works in a bank was investigated. And after investigation in his branch, they found out that it was part of a group of people who defrauded the bank to the tune of about 16 million naira. And after the discovery of this fraud, he was given a query where 10 questions were posed at him, and he was asked to provide his response to these 10 questions. When he responded, he denied being involved in the fraud, but he apologized for his negligence because he admitted that he was negligent in the entire transaction. And some days after he responded to the query, the bank issued a letter congratulating him for long service award because he had spent 10 years with the bank at the time and he was given a gift. However, a few days later, after his long service award, the bank issued a letter cautioning him and telling him to live up to his responsibilities. So, effectively, at the time the bank issued the caution letter, it was deemed or believed that the investigation and the sanctioning for committing that misconduct had been closed. However, a few months later, the bank merged with other financial institutions and they became known as Sky Bank. And when the bank became known as Sky Bank, it was transferred to another department. It was sent for training to make him a better employee. Surprisingly, some days later, the bank issued a letter dismissing him from employment. And in the letter of dismissal, they said that it was fraudulent, it was dishonest, and that he was not fit to work in a financial institution. And after he was dismissed, he commenced a lawsuit at the High Court in Oyo State. And he asked for his salaries for about 2 years from April 2006 to April 2008. He also asked for his salary from May 2008 until judgment was delivered. And at the High Court agreed with him that his dismissal was unlawful. However, the High Court held that well, it was unlawful, but it was effective. So the High Court gave him damages, 1 month salary in lieu of notice, because the High Court held that his contract of employment provided for 1 month salary in lieu of notice. So if his employment was going to be terminated, he ought to be given 1 month salary in lieu of notice. And he was obviously dissatisfied with this and he appealed to the Court of Appeal that the damages he was given was very low. And when he got to the Court of Appeal upheld his appeal and held that the bank was stopped, meaning that the bank was prevented legally from dismissing him from his employment after having sanctioned him by issuing a caution letter. The Court of Appeal then granted all the reliefs he was claiming, his salary for 2 years and some other months that he claimed. And of course, the bank was not happy with this position and the bank appealed to the Supreme Court. And at the Supreme Court held that the Court of Appeal was right in its decision and that you can't punish an employee twice for the same offense. Having issued a caution letter to the employee telling him to be of good behavior and to live up to his responsibility, it was wrong for the bank to dismiss him for the same offense because the investigation had been closed. And the Supreme Court also held that he was entitled to receive salary for 2 years and the other month's salary. And when the Supreme Court upheld the issue of salary, the Supreme Court held that talked about the general position. In employment law, general position is that if you have been unlawfully terminated, you get salary in lieu of notice as provided in your contract. So if your contract says that you get 1 month salary in lieu of notice, that's what the court usually award. But the court in this case held that where an employee is able to establish that by the termination of their employment, they have been embarrassed, their reputation has been destroyed, their capacity to get another job has been significantly diminished. If the employee is able to establish all these facts before the court, then the court would depart from giving him salary in lieu of notice of 1 month, but to give him substantial salary as damages. So the court in this case held that since the bank mentioned that he was fraudulent, he was dishonest, and not fit to work in a financial institution, that has damaged his reputation. And the banker, the claimant himself, the former employee, he gave evidence to show that he couldn't get any job from any other bank or government agency, that whenever he applies for a job, because of the circumstances in which he left the bank, he couldn't get employed. So the court held that he has been able to establish beyond doubt that the dismissal affected him from getting a good job. So in summary, once an employee has been sanctioned for committing a misconduct, an employer cannot sanction him again for the same misconduct. So this means that employers must always patiently investigate any allegation against their employees. If an employer rushes to sanction an employee, and after some months or some days, you now remember that, oh, the sanction I gave him was very small, I want to increase it, that is wrong. And employees too should also know that you can't just sue an employer for terminating your employment and you are asking for 5 years salary, 6 years salary, 7 years salary. If the circumstances of your dismissal or termination of your employment is not one in which your reputation was significantly damaged or your capacity to get another job was impacted, negatively impacted, then you will not be entitled to substantial damages. And finally, a very important point that the Supreme Court made in the case, which I'm very happy about and I'm happy to share, is that the Supreme Court mentioned that the labor law jurisprudence in Nigeria is changing and that the law allows the court to rely on international best practices in labor and employment law. So what does this mean? This means that the courts in Nigeria in delivering judgment and employment disputes can rely on international labor organization conventions, international treaties, international policies and documents to ensure that both the employers and employees are well protected and the rights of both parties are well protected. So in summary, an employer cannot sanction an employee twice for the same offense. Where that happens, the employee would have the right to go to court to claim significant damages against the employer, because the law frowns against double jeopardy in any form, whether be it criminal or civil. I hope you found this video helpful. Thank you very much.